Good afternoon, ladies and gentlemen. Welcome to the YSIAC-YPG-YMG-YSCL Debate. My name is Suen, SIAC's Business Development Manager Legal, and I'm pleased to be your MC this afternoon. Today's debate is on the motion, this House believes that virtual hearings should become the default mode of hearing beyond the pandemic. A gentle reminder that at the end of today's debate segment, there will be a virtual networking session that will take place on the Zoom meeting platform. To join, please click on the link that will be circulated then in the chat box. Please do stay tuned and join us. We will now have Ms. Sharon Chong, member of the YSIAC committee and partner of Screen Malaysia, to give the opening remarks and thereafter moderate today's debate. Ms. Chong, please.
Good evening, ladies and gentlemen. Welcome to the YSIAC-YPG-YMG-YSCL debate. Thank you for joining us today. This is indeed a special day, as I believe this may be the first debate that all four groups have organized together. As you know, these four groups are the young groups of SIAC, AIAC, CIAC Malaysia branch, and SCL Malaysia. For those who are not familiar with these groups, YSIAC is the Young Singapore International Arbitration Centre group, which aims to promote the use of international arbitration and other forms of alternative dispute resolution, both regionally and internationally, and to provide a platform for young professionals to work together to address the unique challenges faced by the legal and business communities across a diverse range of Asian jurisdictions and cultures. YPG is the Young Practitioners Group established under the auspices of Asian International Arbitration Centre in 2017, and it brings together dispute resolution practitioners below the age of 40 and students interested in building their careers in this fast-growing and dynamic field. YMG is the Young Members Group of the Chartered Institute of Arbitrators Malaysia branch, set up in 2013. YMG consists of all the registered CIAC members in Malaysia aged 40 years and under, and was founded with the intent of bringing the younger members together both professionally and socially. YSCL is the Young Society of Construction Law Malaysia, founded in 2020 as a subset of the Society of Construction Law Kuala Lumpur and Malaysia and Selangor, with a membership comprising of junior professionals and students. Their mission is to enhance accessibility and empowering youth in the construction industry. We've brought them all together under one umbrella today, as the members of all four groups are young professionals and practitioners who are involved in arbitration hearings in various ways. We're in for a treat today, as we have four very dynamic young practitioners who will be debating on today's motion. I'm sure that you're all looking forward to hearing from them, and without further ado, I shall now introduce the four speakers. Could I please ask the speakers to turn on their cameras? Okay, I'll start off with Ms. Monisha Cheong. Monisha is an Associate Director at TSMP Law Corporation, a leading boutique law firm in Singapore. As counsel, Monisha has represented clients in various complex and high-value international and domestic arbitrations under the ICC rules, the SIAC rules, and Singapore Institute of Architects rules, and in various arbitration-related court proceedings involving the ICC rules and UNCITRAL rules. Monisha is also a member of the Young SIAC Committee for 2021 and to 2022. Complementing her active arbitration practice, Monisha specializes in construction, infrastructure, and engineering disputes, regularly acting for architects, employers, and contractors at all levels of the Singapore courts, as well as in adjudication proceedings. In addition to her active litigation and arbitration practices, Monisha also has a dynamic cross-border white-collar crime practice, acting on behalf of ultra-high net worth individuals, state-owned enterprises, and foreign domiciled companies to safeguard their interests. Our next speaker is Mr. Samuel Koh, who's a senior associate at Drew & Napier, Singapore, practicing mainly in the areas of commercial litigation and international arbitration. Prior to joining Drew & Napier, he was a Justice's Law Clerk with the Supreme Court of Singapore and a Deputy Public Prosecutor at the Attorney General's Chambers. He graduated with an LLB First Class Honours from the National University of Singapore and also holds an LLM with a specialization in International Legal Studies from New York University. Our third speaker is Mr. Lim Ziwei, who is an associate in the dispute resolution practice at Herbert Smith Freehills, based in Kuala Lumpur. He is a fellow of the Chartered Institute of Arbitrators and co-chair of the Asian International Arbitration Center Young Practitioners Group. Ziwei represents and advises multinational clients in cross-border commercial and investment disputes, including engineering, construction, telecommunications, mergers and acquisitions, and shareholder disputes. He has advised and acted in arbitrations under various institutional rules, including ICSID, ICC, EIAC, UNCITRAL, and SIAC, seated in Europe, the Middle East, North Africa, and Asia. He also possesses working experience with public international law and international commercial disputes under various civil and common law systems. And finally, last but not least, we have Brendan Shin. Brendan was called to the Bar of England and Wales in 2016 and subsequently to the Malaysian Bar in 2017. He joined Azman Davidson and Co. in 2016 and primarily practices in the areas of contentious construction law litigation and tax law litigation. He represents a wide range of local and international clients in construction law matters, including all stages of litigation, arbitration, and adjudication proceedings, whereas his experience in tax law matters includes appeals at the Special Commissioner of Income Tax, High Court, and Court of Appeal. We welcome all our speakers today. Today's motion is this House believes that virtual hearings should become the default mode of hearing beyond the pandemic. The COVID-19 pandemic has impacted businesses on a global scale and has had an unprecedented impact worldwide, where all industries and sectors have been affected. The World Bank, in its 2020 year in review, described it as a truly unprecedented crisis. Due to the travel restrictions that remain in place in most parts of the world, the pandemic has changed the way arbitration proceedings are conducted. Virtual hearings are now the preferred mode of hearing. Nonetheless, should virtual hearings become the default mode of hearing beyond the pandemic? I will be interested to find out from our speakers today. The structure of the debate will be that each of the speakers will get 10 minutes to speak. We will start off with the first speaker for the motion, Monisha, followed by the first speaker against the motion, Samuel, and followed by the second speaker for the motion, Brendan, and last but not least, the second speaker against the motion, Ziwei. Before we proceed to the debate, we will be conducting a poll, which we will conduct again at the end of the debate. If we can, okay. So there is, you will see on your screen the pre-debate poll, and it reads: this House believes that virtual hearings should become the default mode of hearing beyond the pandemic. We have another 10 seconds to go. You still have some time to put in your vote. I think there's another around 20 of you who have yet to vote. You still have some time to put in your vote. So please vote either for the motion or against the motion. We'll be taking the same, conducting the same poll at the end of the debate to see if any of the speakers manage to change your mind. Oh, I believe we are now at a 50-50. That is quite interesting. I think it's quite a close call. Okay, Okay, so 49% of you voted for the motion and 52% of you voted against the motion. It would be really interesting to see if this changes at the end of the debate. Okay, so before without further ado, we will now invite the first speaker for the motion, Ms. Monisha Cheong, to start.
Thank you, Sharon, for that very kind introduction. Good evening, everybody, and thank you so much for joining us for this YSIAC-YPG-YMG-YSCL debate. My name is Monisha Cheong, and I will be arguing for the motion together with my teammate, Brandon. As a quick roadmap for our viewers, I'll be covering some introductory points based on the key terms found in the motion. And because we believe that virtual hearings should become the default mode of hearing beyond the pandemic, we will also extol the virtues of virtual hearings. Brandon will handle the rebuttals to the points made by our learned friends across the aisle who are against the motion, and then cover a few more benefits of virtual hearings if time permits. So our motion today is this House believes that virtual hearings should become the default mode of hearing beyond the pandemic. For starters, let's define some of the key terms in the motion so that all of us are on the same page. So for virtual hearings, we understand virtual hearings to be those conducted purely by audio-visual means, where cases take place without the need for participants or counsel to attend at a centralized hearing venue in person. Default. Obviously, default means standard, and a default situation is a situation that is what is already pre-existing, established, or happening and will continue to do so unless someone or something changes it. Now, hearing, which is the second reference to the word hearing in the motion, and we understand it to mean any and all types of hearing, be they evidentiary, jurisdictional, and everything else. Hearings themselves take place in many different contexts: civil court proceedings, criminal proceedings, arbitration proceedings, etc. However, for the purposes of today's motion, we will generally focus on all types of hearings in an arbitration context. And for the last key term, pandemic, obviously the pandemic refers to the COVID-19 global health crisis that is engulfing the world today. So let's look at some of the assumptions implicit in the motion that are worth highlighting. First, that virtual hearings become the default mode of hearing. This means that there remains the option to switch to in-person hearings or a hybrid part virtual, part in-person hearing if parties so agree or prefer. This is especially important in an arbitration context where party autonomy and freedom to contract form the bedrock of the entire arbitration proceeding. Second, that virtual hearings are not already the default mode of hearing and should become the default mode of hearing. While there has been some take-up in virtual hearings prior to the pandemic, especially for emergency arbitrator proceedings and interim applications, this has remained the exception rather than the norm. As such, the motion contemplates and recognizes that virtual hearings were not the norm pre-COVID-19, and a shift in attitudes and arrangements is required before virtual hearings become the norm. Third, the motion contemplates that virtual hearings are better, or at the very least, present more benefits than in-person hearings, which is why parties to arbitrations should move to having virtual hearings as the default, and indeed the norm, even when all the movement control orders, curfews, and social distancing requirements have been eased after the pandemic is well and truly in the global rearview mirror. So in this vein, I will now segue into the benefits of virtual hearings, thereby explaining why virtual hearings should become the default mode of hearing beyond the pandemic. These benefits are cost savings, time savings, reduction in negative environment externalities, and flexibility. So let me just elaborate on the first benefit, which is the cost savings that are available if virtual hearings become the default mode of hearing beyond the pandemic. From a cost perspective, virtual hearings can be advantageous, especially because counsel, parties, experts, and witnesses are no longer required to travel, which is particularly relevant in multi-jurisdictional disputes. There is no longer the need for parties to allocate a budget for costs such as accommodation, airfare, visas, or venue bookings. Additionally, the necessary technologies for virtual hearings are available at minimal expense. A fraction of the cost for the many participants, a fraction of the cost of travel for the many participants to distant hearings and accommodations there for very long periods. Additionally, our experience of virtual hearings to date suggests that virtual hearings tend to be more focused than hearings in person because counsels strive to make the arguments over video to the tribunal as clearly and concisely as possible. As such, virtual hearings are likely to result in more focused and shorter and therefore more cost-effective hearings. The clear winners at the end of all of this are the users of the arbitration process, the clients. The second benefit is the time savings. It is expected that virtual hearings will naturally lead to time savings. Not only will the buffer of travel time be a consideration of the past, the coordination difficulties and logistical issues of flying in all participants to the place where the hearing will take place are likely to be minimized because participants can log on to and be part of a virtual hearing from the comfort of their own living room if they choose to. As a result, arbitration proceedings are likely to progress more quickly as scheduling issues are going to be minimized. Additionally, significant time can also be saved in the course of a hearing. Virtual hearing platforms usually allow for documents to be pulled up and shared with all participants in the arbitration hearing electronically. When a document or other piece of evidence is referred to during the hearing, every participant has immediate access to it on their screen, and legal teams may also be available to access their own private version of the document with the notes and comments that they have made during the preparatory phase at their fingertips. Live hyperlinks enable instant on-screen connections between specific passages, documents, and transcripts. The effective digital presentation of evidence makes proceedings more efficient, thereby saving significant hearing time. In this vein, an increased use of virtual hearings will ensure that arbitral institutions are better equipped to deal with any future pandemics or similar events requiring public lockdowns or closures of physical hearing chambers. If a similar pandemic happens in the future, which may not be as remote a possibility as we may think, there will not be any time lag where parties press pause on the arbitration proceedings, thinking that life pre-pandemic will continue in a matter of a few months, or scramble to decide how to continue their dispute resolution proceedings when it becomes clear that public health concerns discourage large groups of people from congregating in enclosed spaces such as hearing rooms. Switching to virtual hearings as a default after the COVID-19 pandemic is over will ensure that there is no pause or time lag in deciding how to continue arbitration proceedings the next time a pandemic rolls around. I see that I have 2 minutes left, so let me just summarize my two main points, my two remaining points, one and the third of which is the reduction in the negative impact to the environment. Under this point, I have 2 subpoints to raise, which is that the key benefit of virtual hearings will reduce or eliminate the need for travel, which will potentially have a good impact on the environment, thereby satisfying all our climate change activist friends who believe that air travel is one of the main culprits of the global climate crisis. The second subpoint is that with hearings taking place virtually, it is likely that papers and documents used and submitted as part of the arbitration proceedings are likely to also switch to those in an electronic form, thereby significantly decreasing the amount of printing and paper previously associated with arbitration hearings. My last point before I wrap up is to emphasize that the flexibility of how the format of virtual hearings allows for flexibility, offering parties, practitioners, and arbitrators an unprecedented opportunity to take advantage of the real flexibility offered by by adopting more innovative approaches tailored to deal with particular needs of the case. Virtual hearings will allow cases to proceed in phases, seek and narrow issues where possible, such that the need for an evidentiary hearing is reduced. I see I have 1 minute left. So to sum up, let me just say that in conclusion, virtual hearings allow for greater cost savings, convenience and innovation, and for arbitrations to be freed of its slow, expensive shackles of yesteryear. Therefore, virtual hearings should become the default mode of hearing beyond the pandemic. Thank you, everybody, for your time.
Thank you, Monisha. Thank you very much for keeping to your 10 minutes. Next, we invite Samuel Koh to argue against the motion.
Thank you, Sharon. Well, ladies and gentlemen, the first speaker for the proposition, Monisha, has spoken very eloquently about the various virtues and, as she calls it, advantages and benefits of having virtual hearings. And she says that because of the aforementioned virtues and benefits of virtual hearings, ergo, virtual hearings should become the default mode of hearings even beyond the current COVID-19 pandemic. As the opposition, our position is unequivocally that virtual hearings are not ready to become the default mode of hearings as soon as this COVID-19 pandemic passes. And that's because, first and foremost, of the fact that this motion, if we examine it very closely, I know Monisha has tried to define and set out certain assumptions, but if we examine the key terms of this motion very closely, we see that in spite of all the benefits and advantages that accompany the holding of virtual hearings, it cannot meet this burden of becoming the default mode of hearings. And leading on from that, we'll also go through and talk about the various disadvantages that still plague the mode of virtual hearings as a mode of hearing. And one key area that I will touch on as the first speaker for the opposition is the fact that holding of virtual hearing inevitably affects the quality of the evidence taking and witness examination process in a hearing, which is actually indubitably the pivotal part of a dispute resolution process. And this leads to a highly flawed process. And for this reason, we say that definitely virtual hearings cannot become the default mode of hearing. The second speaker for the opposition, Mr. Lim Ziwei, will touch on two further points as to the demerits accompanying the holding of virtual hearings. And they are the fact that virtual hearings would necessarily lead to due process concerns. And secondly, if time permits, he also touched on the various security and confidentiality concerns that accompany the holding of virtual hearings. Now, first, I will touch on various assumptions and aspects of definitions raised by Monisha. She has tried to define a few terms and they are broadly unobjectionable. In particular, she has referred to a dictionary definition of default. And I paraphrase, I believe she said the default situation would refer to a situation that exists or happens unless someone or something changes it. And the opposition would definitely agree with such a definition. But the opposition would definitely have to emphasize that this motion being about virtual hearings being the default mode of hearing beyond a pandemic means that we are exploring not just virtual hearings being a viable or reliable alternative, or even, if we are a bit more generous, a recommended or preferred option. It has to be a default mode of hearing. And what does this mean? This means that when you say a mode of hearing is the default mode, there's a presumption to import some legal parlance into this analysis that this mode of hearing will apply in all instances, subject to there being exceptional circumstances or compelling reasons as to why this particular mode of hearing should not apply in a particular instance. And so Monisha has earlier mentioned as to how one of the proposition's assumptions is that there will remain an option to switch on the part of parties. And so in short, if they agree or concur, then the the particular mode of hearing can be converted into another mode of hearing. And because of that, they say that because of this assumption, then they go on to argue that virtual hearings can be regarded as being suitable for assuming the role of a default for all future hearings. In respect of this particular assumption, the opposition would challenge that by raising the fact that we have to go back to what the term default stands for. And we say that even though in principle there is definitely an option to switch on the part of parties, and that necessarily accompanies this fundamental principle of party autonomy in all arbitration proceedings, the fact of the matter is that when you try and pivot away from default mode of hearing, this default option, you have to provide good reasons. And in practical terms, when you address the tribunal and you try and justify as to why a virtual hearing, assuming that it is the default, should not be held, you have to provide good reasons to persuade the tribunal as to why the hearing should not be conducted virtually. And so this, I emphasize on this, the opposition emphasizes on this, because we would like to draw attention to the significance of this term default and how it actually inevitably and unfortunately for the proposition colors the entire debate in this manner. As for the rest of the terms defined by Monisha, we also have no objections. In particular, the term virtual, we would say it definitely should encompass hearings that are conducted purely by audiovisual means to allow for different stakeholders to a hearing to attend without being physically present. And we emphasize on this because we say that it should not include instances where there are hybrid hearings as well, because that, we say, if you talk about hybrid hearings, it will be a cop-out to the motion. If you're talking about how virtual hearings should replace physical hearings as a default mode, you have to examine it in an instance when purely audiovisual and virtual and remote technology is employed to facilitate a hearing. Otherwise, you would necessarily have to revert to the current norm, which is physical hearings. Now, moving on to my first substantive argument, then, having established and corrected some of these assumptions regarding the motion, the point that I would like to be taking you through today would simply be the fact that virtual hearings affect the ability of a party to effectively present its case because they lead to attenuation and deficiencies in the evidence taking and witness handling process. Now, you all would be familiar with the term Zoom fatigue. And just to elaborate a little bit on Zoom fatigue, it arises because there is the need to focus incessantly on a flat two-dimensional screen for a long sustained period of time. And because scientific studies have shown that it is naturally more difficult to concentrate on such a flat screen for a long period of time. And also because of the fact that we depend entirely on a single visual input for a source of information, and we have fewer resort to non-verbal cues, it leads to greater need for the viewer to pay huge attention to what's going on before him on the screen, and therefore it results in this phenomenon that we know as Zoom fatigue. And this phenomena, we say, is a huge problem in this process, and it's not one to be downplayed or belittled. And that's because you have other accompanying factors that get thrown in the equation, one of which in an international arbitration context, as Monisha has very kindly limited the scope of this debate to. In international arbitration context, you have very commonly time zone differences. You can have witnesses appearing in Glasgow, another witness calling in from New York, and another from Sydney. And of course, you have someone turning up jet lagged and tired. And all these contribute to the negative impacts of Zoom fatigue that accompany the holding of virtual hearings. The second sub-point that I will make in this regard, regarding how witness handling and evidence taking process is affected by virtual hearings, is the fact that there's limited visual cues in a virtual setting as compared to having a hearing in a physical setting. And this affects all stakeholders, be it arbitrators, counsel, or witnesses. For arbitrators, they won't be able to fully appreciate and see and assess the evidence that is being taken from the witness virtually. Because during in a course of cross-examination in particular, the tribunal will naturally not be able to fully take in and evaluate all the non-verbal cues and body language. This one might suggest is a small and trivial thing, but then we say that this is particularly significant in cases involving allegations of fraud or willful misconduct, whereby issues of credibility come to the fore. And I'm sure practitioners can agree that such instances are actually more common than we would care to admit. And as regards for counsel, the cross-examination process is also inevitably affected in a virtual hearing setting. As much as people nowadays have been increasingly extolling the virtues of virtual hearing and saying they're more and more used to conducting of cross-examinations virtually, the fact of the matter is that a virtual hearing definitely would lead to a slowing down of the usual cut and thrust of questioning. And also there's the fact that one would need to break up his or her examination periods to accommodate for Zoom fatigue.
Samuel, you have 5 seconds.
Oh, yes, I see that my time is up. And so therefore, because of these various small but significant factors that plague the conduct of a virtual hearing, we say that virtual hearings definitely affect the ability of a party to effectively present its case. And this, when viewed against the backdrop that I've presented in respect of the assumptions that accompany this motion, in particular the significance of the term default, for these reasons, the opposition says that this motion definitely cannot stand and virtual hearing should not be the default mode of hearing after the pandemic. Thank you.
Thank you, Samuel. Okay, next, let's hear from Brandon, the second speaker for the motion.
Hello, thank you, Sharon. Thank you, Sharon, for the introduction, and thank you, Samuel, for that presentation. Good evening, ladies and gentlemen. I'm Brandon Shin. I'm the second speaker arguing for the motion. This House believes that virtual hearings should become the default mode of hearing beyond the pandemic. Now, I will first try to rebut some of the points that Mr. Samuel Koh has brought up against the motion, as well as some of the points that he says that his learned friend, Mr. Lim, will bring up, since I will not get a chance to address these later on. Now, first of all, Samuel has brought up that Monisha and I may have copping out slightly on the definition of default. We are fully committed to the definition of default, that default should be as it is default. And we think that parties should be given an opportunity to opt into physical hearings and basically opt out of virtual hearings. Now, the second point that Samuel has mentioned, Zoom fatigue, that basically parties are forced to be more focused, that viewers pay a greater amount of attention, and that this is exasperated by time zone differences. Our argument for this is actually this can be viewed as a pro and a con. Okay, now Zoom fatigue occurs because parties have to pay a great amount of attention. But if you view it from the other hand, parties pay more attention because they are more focused on something. Things can get done more effectively. Now, this is a point that was made by my teammate Monisha. So Zoom fatigue is something that will prevent parties from carrying out hearings throughout 8 hours for prolonged periods. But our argument against this is that there is no need for hearings to go on for 8 hours. I want to address now the second point that Samuel has brought up, which is the point regarding limited visual cues. Now, first of all, Samuel's point really relates to arbitrators not being able to fully see and assess the evidence taken from the witness. They cannot take in the non-verbal cues. And particularly that this is important for fraud, where credibility is crucial. There are a couple of ways that has already there's already been put into practice that will allow parties to better evaluate the evidence given by witnesses. Now, one of these is very simple, which is to put the camera further back from the witness, and this will give a clearer view of the witness, specifically the upper torso of the witness. This will give a more complete picture of how this witness is reacting to the questions, and give the tribunal a better chance to interpret whether this witness could potentially be dishonest or lying during the hearing. Now, one of the points that is commonly brought up maybe is the issue of coaching. Now, this also comes back to dishonesty. There are, again, a number of ways that we can overcome this problem. And one of those is to introduce a secondary 360 or room camera which gives a wider view of the room. This would show all parties if there was any coaching or any off-screen shenanigans, as it may be, during the witness giving his or her evidence. So we recognize that witness integrity is crucial. It is of paramount importance, but there are ways to overcome it, and that should not take away from the benefits of having virtual arbitrations. So now moving on to one of the points that Samuel has said that Mr. Lim will bring up, which is security. So there are always concerns about shadow listeners, or since arbitration is supposed to be a private dispute, that trade secrets or confidential information may potentially leak out if it's not secured. So the key to this is really encryption of the video feeds. Encryption of communication over the internet is not something that's new. It's something that has been around for a long time. Just think about your internet banking, for example. HTTPS, what is the S? The S means secure. Secure because it is encrypted. The information is encrypted between your computer and the server. So it's not that easy for spies or whoever has an ulterior motive to get the details of this arbitration. And Zoom is a popular, obviously, platform. We are using Zoom now. As of October 2020, has rolled out end-to-end encryption. Cisco WebEx is another platform, has end-to-end encryption, and Microsoft Teams does not have end-to-end encryption yet, but it will be bringing end-to-end encryption later this year. So we think that security problems are not something that should dissuade parties from conducting virtual hearings. In fact, parties send documents over the internet all the time. They send arbitration awards through the internet, and I wouldn't say that there are many concerns about email communications being breached and confidential information being leaked. So this shouldn't be a primary reason to stop virtual hearings from going on. I'll now move on to some of my substantive points. So I just want to reiterate what we're arguing, which is that virtual hearings should become the default mode of hearing beyond the pandemic. Just now, I fumbled over the word default a little bit, but I will deal with it again slightly later on during my discussion. So it's already a norm that most of this an arbitration process is already virtual. Discussions of administrative procedural matters can be done over email, video conferencing, and submissions are done electronically. And also we use internet-based file repositories. So none of this is new. When we talk about the virtual hearing, the final remaining process really is the hearing itself. Okay. I want to focus on the bigger picture on why we should have arbitration hearings virtually. And my argument is this: virtual hearings make arbitration more accessible by making it cheaper and more convenient. Okay. Now, I want to set up a few foundational points. First of all, arbitration can be used to settle domestic and international disputes. Prior to this, we were mostly talking in the context of international disputes. Now, it's true that arbitral virtual hearings will truly shine when the dispute relates to multi-jurisdictional international disputes due to ease of enforceability as a result of the New York Convention. The New York Convention is ratified in 167 countries. So the points that I'm making will relate to domestic arbitration to an extent, but as we've tried to narrow the scope of this debate, they will have a much more pronounced effect when dealing with international disputes, especially when we are dealing with costs. Now, building on the points that Monisha has brought up just now, virtual hearings would give parties the convenience of doing it anywhere in the world. Now, the current preferred seats of arbitration is London, Paris, Singapore, Hong Kong, Geneva, New York, or Stockholm, depending on which statistics you read. And a majority of these seats will become the venue as well for the arbitration. This is based on a report by Berwin, Leighton, Paisner in 2019. So if we can move hearings to virtual, we can change the public perception that arbitration has to be conducted in these specific places, and we will effectively be able to remove a barrier of access. Now, this could be a deciding factor for parties in a country outside of these arbitration hotspots. There are many developing countries, such as in Africa, certain parts of Asia, that are not wealthy and nowhere near geographically close to any of these arbitration hotspots. So having an option to being able to bring an arbitration online will remove remove a barrier to arbitration, and it could be the difference between having an arbitration at all or not. Building on Monisha's points regarding cost savings, okay, if we lower the cost of arbitration, we'll be able to allow people with lower claims, okay, to bring an arbitration claim. Now, looking at a survey by Queen Mary University of London in 2019, okay, the question is this: what is the value of a dispute that is commercially sensible to pursue? Now, 47% of participants thought that disputes under 10 million USD is not worth pursuing due to costs.
Brandon, I'll have to ask you to wrap up your final sentence.
Okay, thank you. Right, okay, so maybe I'll just skip to the ending. Thank you so much. Okay, just to re-emphasize the points made by Monisha, virtual hearings allow for greater cost savings, and this would bring arbitration forward and also lower the barrier to arbitration. And this is why we believe that virtual hearings should become the default mode of hearing beyond the pandemic. Thank you.
Thank you very much, Brandon. And finally, let's hear from Zoe, second speaker against the motion.
Thank you, Sharon. Members of the affirmative, members of the House, very good evening. The affirmative has raised fascinating propositions. Largely untenable, but fascinating. My colleague, Mr. Koh, has addressed some of these, but let me register 2 additional points of interest. Now, the first speaker for the affirmative asserts that virtual hearings lead to greener arbitrations, inter alia by reducing carbon emissions arising from the aviation industry. Now, here's an interesting factoid. If you want fast, reliable technology, which you absolutely need in a virtual hearing, it is wrong to assume that the carbon footprint that ensues will be low. And in 2009, it was found that 2 Google searches alone could boil an entire kettle of water for tea. And the point there is that the amount of energy that's actually being used from the ICT industry is actually incredibly high. Based on a on a 2020 study by Ericsson, an ICT firm. The ICT sector's carbon footprint as of 2020 was 730 million tons of CO2 equivalent, which almost matches the CO2 emissions from burning fuel across the aviation industry. And the point there is applicable even today, and it will be amplified today as the rate of use of technology in virtual hearings have to be amplified as more and more, as if in the case that it becomes the default mode of hearing, not just in court, but also in arbitration, as I'll get to in a while. But the underlying assumption of the 2009 statistic, which I mentioned just now, rings true today. And the point there being that if you really want fast and reliable technology, you need to run huge data centers all around the world, and that consumes a great deal of power. Now, if in 2009, the statistics show that Google searches alone from that year could create enough CO2 to match the annual emissions for Laos in that year. So that creates the same amount of carbon emissions as an entire country. Extrapolate that, if you will, to 2021, when cloud computing has permeated almost everything that we've done. And imagine the amount of streaming that goes into the presentation of evidence in the virtual hearing, the presentation of your electronic bundling, which the first speaker of the affirmative has pointed out, and the powering of the various screens that you would need in order to carry out an effective cross-examination in a virtual hearing. That all adds up to a lot of carbon emissions, and that's exactly why virtual hearings are not as green as people think they are. The first speaker for the affirmative also points to several technological advantages, which she relates to virtual hearings. The thing is, though, is that those examples which she's mentioned, things such as electronic bundling, those are already part and parcel of physical hearings. The problem is, though, that the inconveniences of electronic presentation of evidence through virtual hearings can increase the costs, which therefore makes it, as I will submit in a while, more burdensome, and it actually creates an entry barrier to access to justice, both in courts and in arbitration. Now, and this then comes to the second point, which both speakers of the affirmative have stressed throughout their arguments. And that is that virtual hearings will be cheaper and more accessible. Now, no doubt there will be some cost savings for certain type of disputes, but that is not the case in most, particularly where evidence is being tested. And that segues nicely to my first point, which is virtual hearings create a due process risk. Equal opportunities and equal treatment of parties are fundamental principles in litigation and arbitration. And any departure from either of these can amount to due process violations, and in the case of an arbitration, becomes a possible ground to set aside an award or refuse recognition and enforcement. Virtual hearing can bring to the fore inherent differences between the parties that may otherwise have no or less relevance when the parties are heard in person. And this can create an inequality of arms and possible due process concerns. And two examples come to mind. The first is that virtual hearings require sophisticated setups. And most success stories you hear today of virtual hearings actually involve very expensive and established service providers or technological equipment. You would have, for instance, in a large construction dispute or even a mid-sized construction dispute, it is not uncommon to hear of people having one screen for the arbitrators, one screen to see the witness, one screen to see the documents that are being presented, one screen for the counsel's own use, another screen in case you have transcription. That's 5 screens over there. Add to that the cost of electronic presentation of evidence. Now, I mentioned just now that that's really a norm in most arbitrations today. But the point is this: back when you have physical hearings, you could have a peon like myself or some other associate or a pupil do the presentation of evidence on your own. But in the case of a virtual hearing, the inconveniences you have with electronic presentation of evidence are amplified. And that's where you actually need sophisticated service providers to come in. And we have heard of many success stories today, when it comes to arbitration, they would cite the large service providers such as Epic or Opus, and these services do come at a cost, but they are very effective. And when you put all these together, this conceivably poses an entry barrier to a virtual hearing, and there must be care in having this conversation within the bubble. While large commercial parties can afford this kind of setups, this is not always available to most disputants, particularly litigants in court. And unequal access to reliable technology can result from many factors, one of it being financial barriers. Now, the court serves a wide range of users, many of whom are not very well resourced. We are talking here about your SMEs, the ordinary persons on the street. And many of the cases may not even be commercial disputes, but smaller disputes such as personal injury or accident claims. And the same idea applies to arbitration. While arbitration is often thought as dealing with private commercial disputes, it would be wrong to assume that's always targeting users that are well resourced. For instance, for people involved in the construction industry, it is not uncommon to hear of disputants having strained cash flow, particularly subcontractors or contractors, and for many of whom the choice of arbitration was never a preference. It was imposed upon them because of standard form contracts. In fact, my own experience is that I've seen listed companies, which mainly act as main contractors, have on occasion suffered so much cash flow restrictions that they could hardly even afford external counsel. And the same inequality of arms also exists among lawyers. Just to bring a statistic to bear, over 70% of Malaysian lawyers come from small firms or sole proprietors, and we have seen how the pandemic has hit them, much less being able to expect them to afford these large technological setups in order to run an effective virtual hearing. Enforcing virtual hearings upon such parties will heavily restrict their ability to present their case. Now, this is antithetical to access to justice, which would demand that every participant at each layer of the disputes ecosystem be given a fair opportunity to present their case. Now, financial barriers aside, other barriers to technology parity also exist across the ecosystem. For cross-border disputes, there may be a lack of sufficient technology, both in terms of the technology itself or the infrastructure, or reliable electricity supply to allow for that equipment to work. International arbitration, as you would know, involves at times parties situated in all four corners of the world, and a witness situated in a developing country may not have necessarily have the same access to the same technology as someone in Europe, for instance. The second area in which a due process concern can arise is when parties and counsels and potentially experts are located in different time zones, and everyone in this debate has touched upon that to some degree. But time differences would necessarily weigh on the ability of a party to present their case. For instance, if parties are represented by counsel in New York or Singapore, it may be difficult to organize a remote hearing without having someone in New York working in the early hours of the morning, and Singapore counsel working in the evening. And things are even worse if someone's in Melbourne, which is 2 hours ahead of Singapore, where proceedings might go on until midnight. And the pressures may be compounded by Zoom fatigue. The second speaker of the affirmative claims that Zoom fatigue can help people focus on the dispute. But again, there are limitations to human stamina. If you are expected to do a hearing past midnight, there's only so much you can do to focus on the dispute, which in this case also affects the ability to present the case and raises due process concerns for at least one side of the dispute. And while this has been suggested as apologies, let me rephrase that. While it's been suggested that you could shorten hearing days to accommodate time zone differences, this would obviously lengthen the number of hearing days and the length of an arbitration, and therefore increase costs for users in actual fact. Now, I realize that my time is up, and what I would just conclude is that this motion cannot stand. And for the reasons that we on the opposition have said, it diminishes virtual hearings, diminishes the quality of evidence, and undermines the appreciation. The imposition of a preference for virtual hearing creates due process risks, and unfortunately, I couldn't get to it, but also heightened security and confidentiality concerns. And for all those reasons, you can't have it as the default mode of hearing. Thank you.
Thanks, Zoe. A very big thank you to all our speakers today for their very eloquent and persuasive arguments, both for and against the motion. Without stating my personal views on the motion today, I must say that our event today is a testament of the efficacy of virtual hearings. You may have noted that our speakers today are paired with co-speakers from a different jurisdiction. I must congratulate our speakers for their excellent preparation and their seamless collaboration with each other. So I suppose it does work. Question is whether we should make it a default mode of virtual of hearing. In our pre-debate poll, we had 49% voted for the motion, while 52% voted against the motion. Shall we call up a post-debate poll now and find out whether there's been any change in your views on the motion? So it was 49 for and 52 against. I think it's going to be quite a close one as well. You have another few seconds to put in your votes. Oh, wow. We have 50% for and 50% against. Well, I suppose there were one or two of you who changed your mind. Okay, that brings us to the end of the debate. I wish we had time for some questions, but unfortunately, I think we are just about going into the closing. Okay, I'll pass the time back to you, Suen.
Thank you. Thank you all speakers for the exciting debate. I will now invite Ms. Chong to say a few words for the closing remarks. Thank you.
Okay, ladies and gentlemen, thank you for joining us today and for spending your evening with us. You've all been a great participants. Hope to see you all in the networking session that will follow immediately after this, and also in our future events and webinars. Thank you.
Thank you very much, Sharon. All right, everyone, if you look at the chat box, we have shared a link to the virtual networking session. You do not need to leave this webinar. All you need to do is just click on the link and you'll be directed to the meeting platform. We will start at 6 o'clock, so please click on the link now and we'll see you there. Please grab a drink and join us. Thank you.